It's after the holiday, right? Long weekend. We are here again. Today we have pleasure to invite our lawyer, Miss Bo Hou.
Hi.
I know her since she set up her law firm next street actually. So 3 minutes walking distance there, right? And everyone in future you need help, residential, commercial, sales, transactions, you can contact Miss Hou, and she will help us. Actually, I knew her because she, after her law school, and she practicing commercial lease at the beginning. All the deals regarding commercial leasing, I referred to her, and then she did a very, very good job. So that's the reason I invite her come to us to give us a seminar to talk about it, what's important, what's key point in the commercial lease. And also, of course, for sales as well. Small business for sale. And she also did a lot from our agent, for my clients as well. The important is, a lot of agents all the time ask me, David, how can I start with commercial lease, commercial sales? Where can I get the information? I always tell our agent, you don't need to know everything, but you have to know where to find it. First of all, you can contact me in case you need help, but I'm not perfect. Still, I have to search. I have to do a lot of research myself. Secondly, I will tell you where to find the information. So basically, the important is, in our office, everyone has to check our website. Most of information is already there. The people say, oh, I never check our website. That's not right, right? When you need help, check it first. Like commercial sales, commercial lease, I put sample there already. So I will show you one quick one. When you log in, our office website, so you have to see Resource Center, right? In Resource Center, we see if you're doing commercial, you'll be a commercial agent. Let me see. Okay. You're a commercial agent. Here we got the commercial offer forms, everything already there. And at the bottom, let me see. We have samples. Commercial agent, yeah. Oh, sorry, commercial agent. When you get there, you will see all the forms. Commercial real estate forms for sale, for lease, for listing, for business, everything already there, right? And you pull down everything. You will see, so training video also is there. We have 2 or 3 of them there already. So above the video trainings, you will see here, commercial Schedule A clause, agreement for lease, commercial Schedule A. So you click there, most things are already there. So you can copy, paste, you do modification according to your need. You can do whatever you need to do there. So those are things you can go by yourself, look at that, and if you need to change something, you can call me, talk to me. I can give you some advice. But today I'm not here to talk about anything. I give you one handout already there. It's commercial lease. This is about what terms and sometimes we use on MLS. Right? You can read it yourself. So basically today we invited Ms. Hou. She will give us talk about major issue in commercial lease. Now I will hand over to Ms. Hou.
Thank you, David. Thank you. We can.
Yeah, I can turn off that.
Okay. All right.
Let me.
Okay, so hi everyone, my name is Bo, last name Hou. You can all call me Bo, and I left some business card at the front, so if you guys want, you can pick it up when you guys leave today. So thank you, David, for your kind words. So I do know David for a while now. So I've been doing this kind of work for 6 years, doing commercial lease, commercial purchase and sale. And I find commercial lease to be an area that, in terms of drafting the offer to lease, it's mostly done by the agents. And sometimes very important steps are missed in the very beginning and were not discussed. So it becomes when as lawyers, we're doing the review work, often we run into problems with the client or with the landlord. So this is an opportunity for me to share with you some of the experience I've had in the past. I have composed a list of basically 4 pages of issues that often come up with pretty much every single commercial lease, and I want to go through it with you guys. And if you guys have any comments or stories or any things you want to share, feel free. So this is more of a discussion, so for me to also understand what are your problems and what are the issues that you have encountered during the initial stage. So David is absolutely correct in saying that you don't have to know everything, because a lot of the review work is done by the lawyer kind of later on in the process. So we are the ones, as commercial leasing lawyers, we do review the formal lease. So often it's the 20, 30 pages lease that you bring to me from the landlord. But what I want to address today is the drafting the offer to lease. And I have seen in the past as well, some of the agents will do the full lease for the client, like the simple short form ORIA agreement to lease. So I want to touch upon like drafting of the offer to lease and a little bit about the actual full lease agreement. And if you're drafting for client the full lease agreement, what are the issues that you want to be careful of? So the very first thing, it seems very straightforward, very simple, but I find that sometimes people miss is identifying the parties. So it doesn't matter if you're representing the landlord or you're representing a tenant. So it's very important that you first identify who you're dealing with. Okay, so if there is a management company or a leasing company, are you dealing with them? Are you negotiating with them? Who the landlord is. So when you're drafting the offer, like make sure you put down the correct landlord's name. If it's a partnership, if it's a trust, if it's a number company, if it's an operating company. So that's very important. And it's very embarrassing kind of later on we realize, oh, we have the name wrong, right? And then kind of all the document has to be revised. So find out who the landlord is if you're negotiating with a management company. If they have a lawyer, because those are the very first questions that I will ask if when the agent call and say, hey, can you review a commercial lease? I'll ask, is there a management company? Who have you been talking to? Is there a lawyer? Does the landlord have a lawyer who we correspond with, or do we just correspond with the landlord directly? If you're dealing with a small landlord, like most often like an individual landlord, we highly recommend you urge the landlord to seek independent legal advice. So sometimes, especially if you're representing both sides, sort of like you know the landlord and landlord knows the tenant, they just ask an agent, say, hey, can you draft an agreement for us? We highly recommend either side look for an independent lawyer to protect their interest and also to protect your interest, because we don't want to be in a case where there's a conflict down the road and the clients would say, oh, the agent represented both of us, and then it will affect you, right? So when there is individual landlord or individual landlord and tenant, you're representing both sides, look for independent legal advice. So and if you're dealing with a franchise, so if you're helping client buying a company or selling a company that has a commercial lease, make sure you find out from the client or from the landlord, is there a head lease? So often the structure with a franchise is that the franchisor, like the main company, sign the head lease with the landlord. And then whatever your client will be signing, it's a sublease. So find out who the franchisor is and who the sub-landlord is. So sometimes those could be different entity as well. So you can have the franchisor and you can have a different company signing the lease with the landlord. So those are issues that you want to identify from the very beginning and ask those questions. So who these parties are and what their relationships are. So you know whether you're representing the the client selling, or you're representing client buying, or just representing tenant renting, you want to know exactly like who you can contact and what the relationships are. And those are information that from the lawyer's perspective that I would want to know when you bring in a lease for me to review. Okay, and if you're representing the tenant, so usually tenants, you'll be talking to one person, but they're often a company or to be incorporated or have not incorporated yet or have been incorporated. So anytime you're dealing with a company, be very, very careful that you're talking to the authorizing signing officer. Because I have had cases where the agents have done so much work following up with people, with this one client, and they realize they're not even the person who ultimately was signed the offer or signed the document. And all the work you have done really is not, it just kind of went to waste, right? So if you're talking to a client, they're going to incorporate, you want to ask, is there anybody else in the company? Is there a husband, a wife, or a friend, or a relative? And does that person, who the majority shareholder would be, who ultimately will be signing? If the client is a non-resident, so you want to tell them from the get-go that, hey, if you want to sign a commercial lease, you probably want to register a company, and you need a Canadian resident to be part of the director, right? So, and if there is already a company, you want to get their corporate article of incorporation just to double check. I'm sure those are standard for client identification for RICO as well. But you want to see the article of incorporation to protect you so you don't do all the work for nothing. And when you're representing the landlord, so now more and more of our clients, like the Chinese clients, they're buying commercial property, they're renting it out, and they don't know what to do, and they trust agents and they trust lawyers to help them quality control, right? So on the lawyer side, we don't do credit checks, we don't do the actual work in terms of controlling who the tenants are. That's work left to the agents. So some of the advice I would give to you guys is when you collect tenants' information, make sure you do a good job of collecting alternative contact information so you don't lose touch with whoever the tenant is or the potential tenant. Do the credit check, get bank statements. If it's a newly incorporated company, you want to see at least, I would say, 3 to half a year of bank statements. Personal assets, we have seen those forms where the tenant have to fill in like whatever asset they have, like if they have any real property, cars, bank account investments, just to protect the landlord so we know that they can collect from the tenant down the road. If it's a company has been running for some time, you want to see the financial statement. If it's a large company, you want audited financial statement from their accountant and not just like a printout. Those are all the things, due diligence-wise, we should do to protect the landlord, to make sure that if down the road, again, from a liability perspective, if the tenant is not paying anymore, your client, the landlord, is not going to come back and say, hey, how come you didn't do any work? Like now the tenant is not paying, right? So that's things that you need to do as agent to protect yourself. So that's representing the landlord. When you're representing a tenant, so earlier we just discussed if you have multiple parties, like multiple individuals in a corporation, you want to talk to them about the need for either a guarantee or an indemnity. So those two words you probably hear quite a bit in just leasing or also residential rental. So guarantee is different from indemnity. Often with commercial leasing, commercial landlords look for indemnifier rather than guarantee. So guarantee is a softer and a less form of security for the landlord. So guarantee is only if the first level, like if the tenant is not paying or the tenant is not doing their work, then it becomes to the obligation and the responsibility of the guarantor. But for indemnifier, it's different. So for indemnifier, they're jointly basically liable for whatever pay rent, to perform obligations under the lease. So indemnifier is a higher form, more liability for the individual. So if you have 2-3 people in a company, then you want to talk to them about if they all will be indemnifiers, or if they'll all be, or just one of them or 2 of them. If the landlord sometimes I have had cases where landlord look for an indemnifier that's not associated with the company, like a different person who's especially if it's a new company. In that case, you want to talk to the client in the beginning and say, if the landlord look for indemnifier, do you have anybody else? If you deal with a young company, then client should take that into consideration from the beginning of the lease negotiation. And you should consider the possibility of conflict. So let them know from the beginning that everybody is jointly liable. I have had cases where only one person, only one director is the indemnifier when the company has 2-3 people, right? And that ultimately became a problem with the with the company, with the lease, just because the company didn't do so well, and everybody kind of left except for that one indemnifier who is personal liable. So his cars, houses, everything, bank account are basically on the hook for the lease. So representing tenant, talking about indemnifier is one of the first things you should discuss as well. Okay, so after we identify who these parties are, and yeah, go ahead.
Yes, you mentioned that the higher liability under the indemnity.
Yeah.
Who's the liability higher?
Oh, higher in terms of between the guarantor and the indemnifier. Like, so guarantor is less liability, right? So it's the difference, like different word that you use. They carry different level of liability.
How that would impact the liability insurance premium?
No, it doesn't affect the premium for insurance. It's more for the person who's signing the document, for the tenant. So from the landlord's perspective, you always want indemnity, right? Because it's a fuller, more comprehensive coverage. But from the tenant's perspective, from the indemnifier perspective, you want to probably be a guarantor and not an indemnity. Yeah.
So let's say in case a tenant does not pay the rent.
Yeah.
And in the case of guarantor and the indemnifier, can you give an example?
Yeah. So if the tenant doesn't pay rent, if it's only a guarantee, then the landlord has to go after the tenant first, and then to try to recover from the tenant. If the tenant cannot pay or doesn't comply, then the landlord can go after the guarantor, right? So it's kind of a first, second thing. But with indemnity, the landlord can choose to just go after everybody at the same time, right? So it doesn't matter if the indemnifier is part of the company or the company paid or whatever. Like, the landlord can sue the indemnifier at the same time as the tenant. So that's why it's a higher level of and rent is a pretty straightforward one. We're also talking about obligation to repair and obligation to maintain, right? So often with tenant or with the lease, the tenant would have the first responsibility to repair. But if you have an indemnity, then whoever the indemnifier is also have a duty to repair. So it's a higher level, right? So it's they kind of, if somebody is not associated with the company, technically they have to go and see if everything is in compliance with the lease, even though they're not in the property. So that's why it's a higher form of responsibility for the indemnifier, right? Okay. So then once we identify who the parties are, and then we can start drafting the offer to lease. So this is a very important step, as I was saying, because everything in the formal lease is based on your offer to lease. right? So things that's not discussed in the offer to lease or things that is discussed in the offer to lease will have to be carried forward. But things that's not discussed is basically left to the formal lease. So the better the offer to lease is drafted, the easier we have a job negotiating with the landlord and reviewing the lease, and faster we can get the lease signed. And often, keep in mind, I know with commercial lease, some of the smaller units is just a couple $1,000 a month of rent, but the duration of these leases are very long, right? So we're talking mostly about 5 + 5, 5-year term plus a 5-year renewal. So we're talking about 10 years time, everything is governed under the lease agreement. So anything could happen within the 10 years, and if anything happens, guess who the client will come back to, right? So it's a very, very serious legal document, and it all starts with how you negotiate and how you draft the offer to lease. So obviously there are the simple terms term 2 + 2 or 3 + 2, 3 + 5, 3 + 3 or 5 + 5. What the basic rent is there a rent-free period, commencement day, when does lease start, that kind of thing. Those are very standard. I'm sure those are part of what your client is looking for. But there are some of the more complicated ones, and which I will address later on in today's session. So things like use, what your client is using the property for, exclusivity clause, can anybody else in the plaza or anybody else in the complex do the same thing? First right of refusal, which is basically if your client wants to buy the property, your client gets the first right to. Assignment and subleasing clause, and specific tenants and landlords work. So those are a little bit more complex. We'll get into that kind of a little bit later on. And yeah, so the better offer to lease, the easier to negotiate a formal lease with the landlord. And the next thing is the most important thing I want to address today is I often would see in the offer to lease, there's a clause that says tenant will sign landlord's formal lease within 14 days or 10 days after whatever it's accepted, right? So that's please amend that. We never ever want client to sign that kind of clause saying the tenant will sign landlord's formal or standard lease agreement, because we don't know what's in the landlord's formal lease agreement. And there are probably your offer to lease will be 10 pages, 12 pages, and landlord's formal lease is probably 30, 40 pages, right? So a lot of things that's not included in the offer to lease basically is left to whatever the landlord wants, right? So you can change it to saying the tenant has the right to make such changes to the lease as the tenant or its solicitor designates. So that's the preferred modification, basically saying after the offer to lease is signed, the tenant and the tenant's lawyer can review the offer to review the formal lease or the standard lease and make any changes that would be deemed necessary. Or you can say the lease is to be negotiated subject to any amendment as shall be mutually agreed. So basically leave room for the possibility that once the lease is reviewed, once the actual lease is reviewed, as the tenant or as a solicitor for a tenant, we can go back to the landlord and renegotiate some of the terms. Yeah.
Yes, my question here about to this first right of refusal.
Yeah.
If I represent the tenant and I like to have that there,
yeah.
And if I represent the landlord, I may not want that. So if nothing mentioned in the offer or in the by default, what's that?
You don't have first right of refusal.
Okay.
Yeah. 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 So So anything that you want your client to have, try to put it into the offer to lease, right? So I'm gonna go through some of the things I see a lot in the offer that I recommend and some of the wording that I recommend. But the very important thing is when you're doing an offer, don't say the tenant will just sign the standard lease. because then really at that point, there's no point for me to review the formal lease because you will have to sign it, whatever it says, right? So the only thing we can do is just to let the client know what's in the lease. And sometimes the client is not happy about it. It's
So in that case,
Yeah.
so in our standard lease, in our website, I put one condition there.
yeah.
So that the tenant agree to sign the standard lease
Yeah.
prepared by the landlord. But underneath, I put a condition upon the tenant lawyer to review and reasonable negotiation on the standard lease. So you put that there first. As well. Otherwise, as Ms. Bo said, your tenant may lose the case.
Yeah.
Something happen, right?
Yeah, so put conditions in usually like the landlord will have conditions as well, like checking the tenant's credits and stuff. But to protect the tenant, you want to put some kind of review and further negotiation condition. Okay, so then rent. So usually when we talk about rent, it's the capital R, right? So rent. So rent is an all-inclusive concept. So it includes HST, which is like 13% upon the basic rent, which is also called minimum rent. Minimum rent is really what you negotiate with the landlord. Additional rent. So I want to talk a little bit more about additional rent. So additional rent, I know agents and clients often refer it to as the TMI, tax, maintenance, and insurance. So it's actually a lot more than what we sometimes interpret those items are. So first of all, the client should understand that tenant should understand that the additional rent will vary from year to year, and I recommend putting in an adjustment clause because the additional rent is always estimated based on the previous year. So as we know, management fees, tax, everything like insurance will vary. So often what the landlord would do, they will charge more than what they're actually paying. So if you don't have some kind of adjustment, then at the end of the year, your client, the tenant, will just be paying more in additional rent. And if the landlord is not careful and if the landlord is not organized, the landlord will just keep the additional part, like the other part of the money. And I have had cases where the landlord purposely charge higher additional rent because they feel like they're not charging enough in basic rent, right? So it's good to include an adjustment clause. In the standard forms, most commercial lease will have some kind of adjustment clause. But if it's a big commercial tenant and if your client is if your client is very concerned about additional rent, you should specify, for example, how long after the fiscal year your client should get the credit, and if the client has a right to examine the landlord's books. So in that sense, it's just saying after the fiscal year ends, then the tenant should be allowed an option upon written request to look at the like invoices, property tax bills, any kind of improvement that's done to the property, so the tenant has an idea why there is an increase, or if they have to pay more, or if they should get a credit back. So additional rent, probably want to put that in the offer. In terms of tax, so we explain to clients that tax is property tax, but it's not just property tax. So tax is all inclusive. Again, it includes capital tax, business development tax, and educational levy, etc., etc. So I'll give you an example of what's business development tax. So all the stores along Eglinton, so we all know Eglinton is being developed. There's a subway going there. All those commercial units there they're levied, or the government asks the city of Toronto have them pay an extra, I can't remember how many, but an extra percentage of their property tax because the government is paying to develop the business in that area, right? So if your client is the tenant and you're helping tenant rent a property there on Eglinton, in addition to the property tax they have to pay this business development tax as well, right? So it's not just property tax. So I know sometimes we would try to estimate for the client and we say, property tax for a commercial unit is like, say like $8,000 a year, but it could be a lot more. Depends on the location of the property. So what the tenant needs to understand is when we say tax, is any tax that's associated with that property. It's the responsibility of the tenant. Other than obviously the landlord's own income tax or like property gain tax, but any other levy tax is paid the responsibility of the tenant. And operational, that's the maintenance part of it. So things like snow removal, landscaping, security. I want to draw your attention to the fact that in a lot of the lease I see now, there is an additional 15 to 20% management fee. That's basically kind of swept into the category of additional additional rent. So what that means is if the landlord spent $100 in this year for something, right? The landlord can charge your client $115 to $120 as additional of their management fee. So that's usually included in the formal lease agreement. But I think it's something good for you guys to know, for everyone to know, when you're negotiating the additional rent. The client may have a good idea, or when you talk to the landlord, you have an idea of saying, okay, additional rent is $14.50 a square feet. What does that include? What's your management fee? What's your extra percentage management fee, right? So it's pretty common, and then that's something that when I do the lease review, a lot of clients get very surprised to hear. Okay. Then utilities. So usually utilities are always separate, right? So the client will set up their own hydro gas account. Water is a tricky one. Not all commercial units have separate metered water. So the funny story is that I had a client who is going to rent a property as a salon. And then the unit right next door is an office. And who's going to use more water? But they have the same water meter. And the landlord just says, okay, well, we just split it half and half based on square footage. And obviously the unit next door is very unhappy with that arrangement. So when you help a client rent, or if you're the landlord renting out, that's why use is really important, like what you're using the property for. Is it an office? Is it like a restaurant? Is it a dine-in or sit-out, a takeout? That kind of things, because it will affect how you draft the lease. If it's not separately metered, then yeah, look at who the neighbors are. See if your client is agreeable to, say, like a 30-70 kind of share, or if there's residential units upstairs, those can get a little bit more complicated. But the takeaway message with utility is there is no standard law in terms of how you should pay your utilities or how lease should be. So it's all based on contract. So it's all based on what the lease says. And again, it could be a 5-year, 10-year contract, right? So confirm those items. And then once we are negotiated with, everybody agree on the rent, additional rent, utilities, that's when you need to set a formal commencement date. So with lease beginning, like where commencement date, it seems straightforward enough, but sometimes we get into the problem where, one, if there's a fixturing period, or if there is any work that has to be done by the landlord first. So those, when you set that date, it's not just, oh, let's just do the beginning of next month, right? Or no, September 1st seems like a good date, right? You should take into consideration what, if there's any work that has to be done in the unit. So if there's any landlord's work has to be done, you probably want to put it in your lease agreement or offer to lease to say that the commencement date is October 1st, but subject to the landlord completing their work by a certain date, and to the tenant satisfaction, right? So that way you protect your client to ensure that when they go into the property, they can begin work, and because they're starting to pay rent. I have had cases where the client gets 2 or 3 months of fixturing period, basically basic rent free, but the landlord's work is not complete, so it kind of eat into the tenant's fixturing period. But once everything is signed, if you don't have those conditions or subject to the landlord completing their work first, it's just a loss to the tenant. The tenant will just have to continue on, take possession. It's hard to go at that point go back to renegotiate with the landlord.
Well, can I say something? For commencement day and fixture period. So what day sometimes is the fixture period can be same day as commencement day. Sometimes they give you 2 months, 3 months free rent period. So the free rent period can be before the commencement date or after commencement date. So it depends on the lease, right?
Yeah, it depends on the lease. Usually we suggest that the commencement date should be after, because then your client get a full 5 years, right? Rather than 5 years but sort of have less, like 2 months, right? So you want you can say the first 2 months is fixturing period, and then the commencement date starts after it. That's typically what both parties want.
That's great.
Yeah.
So sometimes they say occupancy date, right? So fixture period. So
Yeah.
different term you can use.
Yeah.
So when you prepare offer, please be aware.
Yeah, another term they use is early possession or early entry. Like the tenant can go into the unit at which day, like say August 1st, and from August to October is the fixturing period, and then the lease commencement date is like say November 1st. So, yeah.
So between this fixed rate for all utilities and the additional TMI, who's going to pay for that?
So usually during the fixturing period, the tenant pay at least for the utilities. So you can say, so in that time you can just say gross rent free, but with exception to utilities, with exception to utilities. But I have also had seen it's just basic rent free, where then the tenants still have to pay like the additional rent. So again, this is how you negotiate the rent free period.
Yeah, in most cases, additional rent you have to pay. When we're talking about net rent free, so that means you pay net rent free, you have to pay TMI, you pay utility, water, everything you have to pay as well. Of course, some landlord depend on some office, right? If some office they stay here forever and never rent it out, in that kind of period, so you can as the tenant agent, you have your power to argue more. You can get more benefit. You can say gross, as a boss said, you can ask for gross rent free, not net rent free. So it depends.
Yeah, so it's a little word makes a big difference.
That's
how
right.
you negotiate when you're talking about lease. Another thing you can concept is called the leasehold improvement allowance. So instead of sometimes landlord they don't give a free period, they will give you X amount of dollars per square footage for you to come in to do renovation. Because every time tenant move in, they repaint the walls, right? Like rip up the carpet. So that's called leasehold improvement allowance. Again, that's something you can, if you represent a tenant, you can ask the landlord if instead of a rent-free period, if they can give a lump sum of money, like a couple $1,000 in lieu of, instead of the fixturing period. Okay. So the next thing is intention of party. So this is an interesting concept. Often you probably see lease that says it's an absolute net lease, or it's a net lease, or sometimes it's a triple net lease. Pretty much they all mean sort of the same thing in legal wise. It just means that the tenant is responsible for paying everything. So that's when I recommend always add, if you see a lease that says this is a triple net lease or this is a net lease, to add except as expressed herein set out. So basically that means it's a net lease, like the tenant will pay for everything except for whatever it's in the lease agreement that the landlord is supposed to pay or to be responsible of. So, however, the law really says even if it says it's a net lease, as long as the lease clearly state what the landlord's responsibility and what the landlord has to pay for, by just saying it's a net lease, it's not enough to have the tenant pay for everything. Okay, so it's an interesting concept if you see net lease or triple net lease, you can explain to the client what it means and probably want to add that except as expressly herein set out. Okay. So the next thing, property. So these concepts all seem very straightforward when you first look at it, but then when you encounter issues, you realize, oh, there's a lot more to it. So with property and a premise, make sure you insert the full description. So things like if there's a patio, if there's the basement, is that included in what your client's renting or your client wants to rent? We have had landlords where they don't want to rent out the basement, actually for compliance reasons, because they finished the basement without getting permit. So they don't want the tenant to use it. Actually, they don't mind the tenant using it, but they don't want to put it in the lease because they don't want the tenant to use it. And one day say, there wasn't a permit and there was a retrofit issue with the basement, right? So, but you want to be very clear with what your client can use and what's included in the lease agreement. So basement, second floor, outside storage, if there's any associated parking spaces, those are issues that often I see kind of get added once I talk to the client, and the client's like, oh yeah, there is like a kind of an attic or like a mezzanine area. Can I use that? And then the agent have to kind of add, yeah.
Yeah, one thing I have to mention here. Regarding for the square footage area, right?
Mm-hmm.
So in the lease, very often they say rentable area. The other one they say usable area, the different term. Make sure that we have it as a lot of issue. One of the agents called me about, I think, a few months ago, the commercial lease. In the lease, they say 5,600 square foot. Then they hire someone, specialist, to do measurement. You say only about 4,000 square foot. Then they argue with the landlord. The landlord, because the lease is not mentioned that whether rentable area or usable area. So rentable area, that means gross area, everything included. Common elements, whatever included. Stairway, staircase, whatever. That's rentable area. Usable area, that's only you can measure the measurement. So in that way, as an agent, when you prepare offer, make sure square footage, rentable or lease, the usable. Make sure that, in our case, the landlord, they got off the hook. The same, in the lease, we always say gross area. So the tenant's family, she had to pay whatever according to the lease.
Yeah.
So make sure we're happy.
All of the information from the MLSL says also is generally rentable.
Should be rentable area. So in the lease, it did not say anything. I suggest you put something there to protect yourself. Rentable area, how many square feet. Right?
Yeah, that's a really good point. And it's pretty much every lease that comes in, I always explain that to the client. And basically, once the client signs, saying they commit to 2,000, 5,000 square feet, once they go in, if they find out it's less, it doesn't matter. Like at that point, it's just you have basically, from the tenant's perspective, you have agreed to the size of the property being 2,000, 5,000, whatever it is. And it's I haven't had any success arguing with the landlord so far, trying to reduce the rent because the actual usable space is less. So that's with the property, verify square footage. And on that point about having the number you get from the MLS. So MLS listing is an advertisement. It doesn't actually become part of the contract. So even if, say, they misrepresented on the MLS, it doesn't mean, like, it doesn't affect the contract itself. So the only thing you can do is to complain the listing agent for misrepresenting, but it doesn't actually affect you cannot really say the MLS has a different square footage than what the actual ones, because it's not part of the lease. Yeah.
Yeah, regarding that one, raised a good point, because of the William elaborate also something listing, when you do listing on MLS, whether residential, commercial, the same thing. Mm-hmm. Whatever you put there, as both say, is advertising. Mm-hmm. Nothing to do with the seller and buyer. Mm-hmm. If the buyer found out something wrong, listing agent, you are responsible. So they can bring you to the record, they can bring you to the court. You are misrepresented, not the seller. So make sure if you do listing, you have to do everything you made should be verified, correct?
Yes, and for this commercial condominium, like office commercial company.
Oh, thank you.
Yeah.
And the only way you can find the square footage will be the builder's
Floor plan. Yeah.
So that may or may not be a usable area.
So in that way, if you're a listing agent, if you're not quite sure that you have, say, gross area or let's say rentable area or whatever, if you cannot verify it. So you don't say usable area. That's important.
Okay.
Yeah.
Okay, so the next thing is security deposit versus deposit. So sometimes landlord look for both kind of deposit. So, but they're different. So security deposit is the amount that designated by landlord to cover the tenant's failure to comply. And if the landlord has to use it, the tenant has to replenish it, and it's to be returned after the lease term. So that's security deposit, and usually it's 1 to 3 months rent. From the tenant side, we typically want the landlord to not collect it. We want to just say we'll give you first and last 2 months rent as deposit, but no security deposit, right? Because this way, we as the tenant there's less output from the beginning, right? Because often with commercial lease, a month's rent could be $10,000 or like to $15,000. And then 3 months rent could be easily $50,000, and that money just gets sit with the landlord for the duration of the 5-year term. So with security deposit, if possible, from the tenant side, we want to delete it. We want to say we'll just give you 2 months rent as the last month's rent. So that's what deposit is. So deposit can only be applied to rent. So if you say upon the acceptance of this offer, the tenant will provide first and last 2 months rent, right? That can only be applied to rent, and the landlord cannot use it for anything else, right? So landlord can only use it for the last 2 months rent, and that's it. So for any kind of repair or any other problems under the lease, the landlord cannot touch that money. So, yeah.
Question about this. I run into a situation like a hybrid residential and commercial. The reason for that is it's a residential property, but the company rented that for their staff, for their employee.
Okay. Yeah.
And by transferring employees, so you won't have the particular name on this living there.
Right.
It change.
Okay.
So in that case, I don't know whether I should use a commercial lease or I can use the residential lease. If the residential lease, you cannot collect a security deposit.
Right. Yeah, so in that case, I would recommend to do 2 separate leases. So one for the commercial portion and one for the residential portion. And for the residential portion, you probably want to do a term to allow for subleasing. Subleasing. So for the residential portion, you don't collect deposit. or security deposit, right? But for the commercial portion, you can. Yeah. Yeah. Okay. And again, from the landlord's perspective, obviously you want the security deposit. You want as many months as possible so if you're secure and if there's anything can happen, a security deposit is a good way for the landlord to protect itself and can just take money out of it, do whatever it needs to be done, and have the tenant pay it back. Okay. Use and exclusivity clause. So same thing. The interest for tenant and the landlord is always kind of on the opposite sides. So when you're acting for the tenant, you want to be as general as possible, and when you're acting for the landlord, you want to be as specific as possible. So if you represent a tenant and the tenant is a bakery, so rather than saying bakery, like use of the property, bakery, you want to say for the sale of bread, rolls, pastries, and ancillary to principal use, including gift products and beverages. Because with bakery, sometimes we know they sell like coffee, tea. They could also sell like candles or like like gift wrapping paper, stuff like that. So you want to be as general, as inclusive as you can, so that when your client is operating the bakery, the landlord is not going to say, hey, why are you selling, bubble tea, or you're selling this. But as long as it's ancillary to, so as long as it's not the main purpose of the property, then your tenant can get away with selling those items. Okay, so that's why I want to try to be as general as possible. For example, with restaurants, you want to consider if it's a takeout or dine-in, right? Consider if your client want to sell alcohol. So if it's a restaurant, there's maybe a bar component to it. You want to put in for the sale of alcoholic beverages. That's very important because sometimes certain landlords don't want any of their premises to sell alcoholic beverages. So you want to put that in. Adding style will broaden the use of the restaurant. So instead of saying a Chinese restaurant, right, you could say Chinese style restaurant, or Korean style, or Japanese style. That broadens the range. It could, like for example, if you're doing a Chinese style restaurant, like that could be a fusion Chinese restaurant, so it really broadens. It seems really minor, but we have cases that argues, before the court over this kind of wording, because the landlord would say you're in breach of your lease because it's not allowed for this, right? Same thing with like convenience stores, right? Anything you probably want to, if you're representing a tenant, you want to broaden it as much as possible. But from the landlord side, you want to control it as much because especially if you are a commercial landlord, you own, say, like several units in this plaza, then you want to make sure like exactly what everybody's doing to avoid competition. So that's where the exclusivity clause also come in. Exclusivity clause, it could be beneficial for both parties. So it could be beneficial for the landlord and the tenant, because for the landlord, when you have a plaza or have a few tenants that they don't compete with each other, number one, you will attract good tenants who business will be successful and will be profitable, and also you have greater control of which unit is doing what, right? And for the tenant, obviously it will attract the tenant because they know they're the only, say, bubble tea, or they're the only noodle shop in that plaza. So definitely want to negotiate exclusivity clause. If your client is in a shopping center, in a small plaza, you want to ask your client or ask the landlord if that's something you can put it in. For condominiums, if the unit is part of a condominium, so we know that by if there's a status certificate, or you can check the legal description of the unit. So you should always order the status certificate doesn't matter if representing the landlord or the tenant, ask the lawyer to go through the status certificate to ensure there is no issues with the condo's bylaw and regulation. Because certain commercial condos, they have specific bylaws saying this unit can only be used for retail. This unit could only be used for this, and that's part of the whole condominium's rules. And the landlord themselves may not know this. They just bought a unit. They've always been using it for an office. They have no problem. But if you want to switch to change it to retail, you want to check if that conflicts with the condominium's bylaw or regulation. And that's also a good way to see if there's anything outstanding with the condo, if there's any outstanding order, maintenance order, or there's any litigations, or just the same kind of stuff you want to look at for residential as well. If same thing for commercial. If it's in a condo, look at the status certificate. Zoning and municipal regulations. So that's the responsibility of the tenant. So the tenant needs to be satisfied itself as to whether the property can be used for retail or for zoning, dining in. So we had cases where it's one of those smaller units underneath the residential building. It used to be a nail salon, and the client want to convert it into a takeout with some seating of like a fast food kind of thing, right? And then they realized the municipal zoning for that unit, while it is okay to do a restaurant, but there's a parking limit for how many parking can be associated with the property. So the client cannot have any kind of dine in. It can strictly be takeout. So, you know, if the client said, oh, the place looks pretty big, like I'm just put out like a couple of chairs, but you want to make sure that you check the zoning, check the bylaws. Parking is a huge one. Often, like the city has limitations on how many parking units is associated with one unit for one commercial unit, and that limits what that place can do or cannot do. Okay.
Okay. One thing when about talking about use, zoning, very very important. As agent, if you are representing a tenant, make sure that a lot of things that David was important in the offer to lease. I say one important is the use, zoning by law. And some plaza, you ask the landlord say yes, you can do this. You ask for the management office, they say yes, you can do it. When you go to the city, they say no, not use zoning by law. So you have to. That's why in the offer to lease, I put the one condition there. Condition for your tenant to verify the use with landlord, with management office, with the city within 10 days. So you have to put that clause to protect yourself, protect your tenant. So that's very important. Okay.
Yeah, and also that's something you like the example I gave, like whether it's takeout or dine in. So you want to have a very detailed conversation with your client to know exactly what they want to do. Because sometimes the clients say, "Oh, I'll just open a restaurant," or something very simple, right? But they don't. Maybe if you don't ask, they won't tell you, right? You need to ask, like, would you have people sitting in? How many people, right? Is it like you have to ask those questions so the client can tell you, and then you can verify if it's possible for that unit to do what the client wishes. Okay. Yeah, so with zoning and municipal regulations, I also recommend putting a representation and warranty or a condition, like what David said. So sometimes I see in the offer, it would say the landlord represent and warrants that the property is within the proper zoning for a restaurant, right? So that way you also share that responsibility, or there's an additional protection for everyone, that the property can be used for whatever your client wants to do. Okay, so maintenance and repair, alterations, and HVAC, which is heating, ventilation, air conditioning system. So this is a huge part I would recommend putting into the offer to lease, because if it's left for the landlord would just say everything is the tenant's responsibility, right? So when you're drafting maintenance and repair, or you're advising the client, be aware of the two notions. So one is the responsibility to fix, and the other is cost. So you could say that landlord has to fix this, right? Or landlord shall fix or repair the HVAC. But sometimes in the lease, then we see the cost then is shared, downloaded to the tenant, right? So if you want to say the landlord at its sole cost shall fix or repair the HVAC, then the landlord has to be responsible for the cost, right? So that's kind of, it has to go hand in hand, but you want to put in a positive obligation. So the question we had earlier is like, if you don't put anything in, what's the default? Like, what's the standard? There really is no standard or default with commercial lease in terms of repair obligations. Again, it's whatever you put into the lease. So if you want the landlord to be responsible for something, you want to say the landlord shall be responsible for this and this and this. The common ones we see, so the landlord should usually be responsible for roof, foundation, exterior walls, any structural walls within the units. Some often the landlord would repair or replace the HVAC, but the cost of that is basically downloaded to the client. That's very normal. If your client is a standalone unit, sometimes like basically it's just a house by itself, a commercial property by itself, then I have seen lease where basically it says everything is the responsibility of the tenant, and the tenants understand and agree, including the roof, including the outside parking, including that kind of the outside, like repaving of the driveway, repaving of the parking lot. So it depends again, like what unit your client is renting. If your client is renting in an office like building like this, then most likely your tenant is responsible for everything within the walls. So things like all these light fixtures, plumbing within the unit, electric circuit within the unit, those are typically the responsibility of the tenant. If your tenant has a huge plate glass, those like nail salons or any kind of retail you see, it's recommended that they get plate glass insurance because it's very expensive to replace. Those big glass windows, like from ceiling to door, those plate glass, we recommend them to get plate glass insurance because that's the responsibility of the tenant. So usually with commercial lease, the client gets kind of upset of how much they have to do, and it's a problem sometimes during the term of the lease. So we want to add in like things like reasonable wear and tear accepted to protect the tenant, so the landlord cannot come in and say you need to fix this and this and this, and if you don't fix it, you're in breach of your lease. By putting in reasonable wear and tear accepted, it's helpful. And with any capital cost or improvement, it's good to put in things like it can be amortized over the useful life, so that your client is not paying one lump sum for that year.
Say something?
Yeah.
For this clause, Hvac, we call it heating, ventilation, air conditioning system. That's a short form. Okay. That's in order to lease. Very, very important, because that's if you represent a tenant, a lot of things issue will be coming up. First of all, heating system, air conditioning, sometimes working condition, on closing when commence that lease. But later on, something goes wrong, break down. Of course, in the offer to lease, I prepare this. The tenant responsible to repair and maintenance. But in case, I put also one more sentence there. In case that the system is broken down, needs to be replaced, who's going to pay for that? You have to make sure writing something there. Because it's coming to a lot of cases. One I remember, young shepherd restaurant, rooftop air conditioning, 50,000 to be replaced. The tenant moving in said, it's not working. The landlord said, you are tenant, you pay for that. So if you don't say something there, the tenant will be a lot of damage. So you have to say what we suggest. Something replacement in our office lease I prepare at the landlord's cost, but in many cases landlord they don't agree. One case so far, Harrison, our agent, he just bought a printing shop. Next time you can go to get some cheaper printing, okay, Flyer, whatever. We call it by Shepherd. We call it by Nico, the shop name. The landlord will argue this clause for 1 week. The landlord said, you are responsible. If something goes wrong, you are going to fix that rooftop air conditioning, which is about $20,000. But our agent accepted our agent Harrison and said, no, that should be, if they wanted to do that, we have to do proportion. That means according to the lease, because they have lifespan, right? Air conditioning, whatever lifespan, 10 years, 20 years. So whatever lease, say 5 years, I can only pay up to my lease term. So that's why we have to suggest proportion according to the lease. So in that way, maybe it's much safer. So finally, landlord agreed. Then the offer accept already. Harrison going to close the deal soon. 8, number August 8. Later on, the people can go to the shop, do your price or whatever. Right?
Yeah.
Okay, thank you.
Yeah. So, yeah, I think I also mentioned here, you should always conduct an inspection before the commencement date and put in a representation warranty that all electrical, mechanical, plumbing, HVAC are in good working condition at the beginning of the term, right? So do a walkthrough with the client. I have had cases where basically it's not completed, like the landlord just bought it from the builder. So you want to do the walkthrough, maybe even with somebody with a technical background, because for example, for me, I wouldn't know if something's working or broken, right? So you want to take the client, maybe have some renovation or the contractors come in as well, take a look at the unit, see if everything is working, or if it's about to break, right? If it's really old or that kind of things, right? So you can prepare your client and prepare the offer to lease accordingly. Actually, then I think I'm going to skip to landlord's work and tenant's work because it's kind of related. So make sure the client consult a professional contractor to determine the extent of the work, and this will affect whether the work should be the landlord's work or the tenant's work. It's really, really important that you do this because we had a case where everything is fine at the beginning of the term. The client, they want to modify an existing restaurant to open up an Egg Smart. So it's a breakfast shop, right? And then it's a great location. Everything's ready to go. And then when the client brought in the contractors to prepare the place, the contractor said, "Oh, the existing film output is too small, and in order to install like the proper film hood, they need to drill a bigger hole on the exterior wall going outside." And the landlord wouldn't agree to it. So then everybody is like completely caught by surprise. And obviously the relationship between the tenant and the landlord quickly became very tense and it broken down. And then the tenant cannot proceed with anything without resolving this issue. And this all because the tenant, when the lease was signed, despite the fact the tenant wrote they will add a washroom here or like redo the kitchen there, it wasn't specifically put into the lease agreement that a tenant can drill this hole on the exterior wall, and the landlord wouldn't agree to it. And yes, like we always put in with the consent of the landlord, which shall not be unreasonably withheld. But when you start arguing what's considered reasonable, it becomes a really difficult test. Because the landlord could argue that, oh, if you do this hole, then there's all these technical implications, this and that. It becomes it becomes very lengthy. And I think in the end, the client had to move out. Like the lease they agreed to terminate the lease. But I think pretty much half a year went by. And when the client had all this business loan, everything lined up. but the business didn't take off. So especially if you're working, because I work with a lot of young entrepreneurs, they like to do like bubble tea, or like they have smaller units and they don't have any experience in terms of renovation. And they think it's really easy. We'll just, do a washroom here. And being compliant is really big as well, because a lot of the older units, they don't have accessibility compliance. And when the unit becomes renovated, then the government is saying, okay, you can't just have one washroom. You need to have a washroom with accessibility, like wheelchair accessible. I had a client who wants to rent a gym over at the Victoria Park and like the Consumer Road area. And it's an existing gym, but the landlord said if you want to come in to do the work, you have to bring it up to date. And then the client, that I told the client that they need to look into whether it's accessible, right? So then they realized it's a huge project because they need to widen the hallway to make sure it's wheelchair accessible, to be compliant with the city bylaw. When it's really silly because it's like a gym. But anyways, so then that lease didn't go through as well, right? So things like tenants work and landlords work, we recommend, it's not within our expertise to give client those advice what needs to be done in terms of the actual technical work. So you should bring it up with the client, also to protect yourself so they don't come back and say, oh, I thought you're the agent, or how come you don't know, how come you didn't put it in, right? So I hear that a lot, and it's just a shame, right? Because sometimes it's really the client themselves maybe not having experience, but it becomes a disaster. It could become a disaster in the end. So landlords work, tenants work. Also, I've seen clauses where it says that they need to use the landlord's own contractor or pick from a selection of the landlord's contractor. And sometimes clients don't like that. I mean, a lot of times tenants wouldn't want that. But if you're the landlord, you probably want to put it in, right? So that you have quality control. So you know that work is being done by trusted parties using good material. Anytime, I didn't put it here, but anytime if you're doing any kind of electric work, you want to ask if the landlord could provide you with existing drawing of the unit, any kind of existing wiring of the unit. Again, this is a problem kind of in the older properties, because sometimes the property has been gone through so many different hands, so many different owners. They don't have anything. Actually, I don't know this, but I have had a client who claims that they cannot do any work because the landlord cannot provide them with the drawing, right? So if, like, again, I think it's more of a technical thing, but you want to talk to your client and see if they can get permits, if they are doing a lot of renovation, so you can put it into the offer to say that the landlord should or has to provide this and this, so it's not a problem down the road. Right. So landlords and tenants work. Okay, so then I'm gonna go back to assignment and subleasing. Sublease. So assignment, it can be negotiated. Usually, it would just say no assignment without the prior consent of the landlord, which shall not be unreasonably withheld. Which is fine. That's fine. Usually, most of the landlord I have dealt with are pretty reasonable. I haven't had a case where I had to argue that with the landlord. But I would want to put in, or if it's up to me, then I would want to put in more specific criteria. So things like the financial capability of the assignee, like the next tenant, just so that everybody is clear what's considered reasonable and what's not considered reasonable. Or you can say no assignment within the first 2 years or first year or first 3 years, to give, especially if representing the landlord, you don't want this tenant to come in and they assign it like 6 months later and like 8 months later somebody else, right? So you could put in no assignment within the first whatever amount of years. Want to talk about this option to terminate. So we actually see it. We do see it in leases where the landlord has an option to terminate if you terminate the lease if the tenant requests for assignment. So again, this is one of those clauses. It could go both ways. Some client actually like seeing it. I have had a tenant that said, "Oh, good. If I request for assignment, it's probably because my business is not doing so well, and I would just I'm okay with the landlord just taking it, right, terminating it, so I don't have to pay any more rent, right?" So for that client, having that clause there, the client was okay with it. They understand if they want to assign it or sell the business, the landlord basically have a first right of refusal. The landlord could come in and terminate the lease. But for clients whose interest is if they want to buy the business and they consider selling it in the future, then they probably want to delete this clause, right? So they want to prevent the landlord from taking away the business, right? Because when it says landlord can terminate lease, it doesn't mean the landlord will have to buy the business. It just means the landlord not going to collect rent anymore, right? So this is a clause I do see sometimes in leases. Some clients like it, some people don't like it. If you're representing the landlord, you probably want to ask the landlord as well, do you want the option to terminate, or do you have to basically without other reason you have to assign, right?
Yeah, it's the same case. Helping or Harrison regarding this termination. The landlord standardly say the landlord has the right to terminate the lease in case the tenant wants to sell the business or whatever. For this term, Bob helped Harrison fight with the landlord for 2 weeks. Finally, they agreed to.
They deleted. Yeah.
So that's a case, and that's really important as well.
Yeah. So go ahead.
Yeah, my question about assignment or sublease, and there could be the profit making, and when you represent the landlord, and you may not want your tenant to make profit on your property. So what kind of costing can you use for that?
Okay, so with assignment, usually it's okay because it's assigned the current existing term, right? With subleasing, there is a clause that would say that the tenant cannot sublease higher than whatever the term, whatever the rent they're paying now. Although it's really hard to control in reality, right? It's really hard to control because I have had landlords where the tenant would do other sort of organization with their corporation to still make a profit. That's why with assignments, like the landlord, if they have any suspicion that they're making a profit, that's why they can say we're not going to agree to assignment or subleasing. That's a valid reason, right? So the control still lies within the landlord.
There's a little different, I think so. Sublease and assignment. Assignment means the landlord will sign assignment directly with the subtenant. For the sublease, will be between the sub-landlord and subtenant. So that we have to make sure that we understood that. So which one is better, depending on, as Bob said, depending on the rate, depending on other terms and conditions. So for assignment, of course, maybe better for the sub-landlord. But for sublease, maybe good for the subtenant. So it still depends on how you negotiate.
So
the landlord can use that as an excuse, so not to give the consent.
You can, yeah. If the landlord feels like the tenant is taking advantage of the lease, the landlord doesn't have to consent. That's a reasonable term. Yeah.
But when you represent the tenant, and the argument could be, I have so much of a lease improvement there, therefore, and ask for more.
Yeah,
you can argue it. You can approve whatever you have.
Yeah, it becomes like it's always an argument between the both sides. That's also okay. So that's a good point. Where then you probably want to put in assignment costs, right? So sometimes the landlord will say, I will agree to an assignment, but I will charge you $3,000 and plus legal fees, right? So,
Or profit sharing.
No problem.
yeah. Well, it's yeah, like assignment. It's a difficult issue because it gets involves so many parties. But I think what we need to keep in mind of is if you represent a tenant, you want the flexibility when you're drafting. You want the flexibility, and you probably want to eliminate things like landlord can terminate or no assignment within how many years. No assignment fee, right? Free of cost, like things like that. You want to you can put it in to help the client, to give your client more flexibility to assign down the road. But if you're a landlord, right, like on the other side, you probably want to say the tenant will be responsible for assignment fees, right? And legal costs associated with assignment, right? So kind of you need to change the different roles to put in different clauses if you're representing different parties. Right, change of control is also considered an assignment. So I have clients where, again, like the business is not doing so well. They want to sell the business, but no one is buying the business. And then they just have friends or like other people they know. They will come into the property. They will just assume running the business without paying anything. That's considered a change of control. And if the landlord finds out, then that's constitute a breach under the lease, right? So that's considered assignment. So if they sell the shares, right? If the main shareholder used to own 70%, and then that's the main person who's been running the business, and suddenly it's somebody else, that person went back to China or went to do other things, that's considered change of control, and the landlord needs to agree, or else it's a breach of the lease agreement. So naturally, I want to talk about pretty much we're almost at the end of the session. I want to talk about default and destruction. So this is something that almost I never see in the lease to offer, which is fine because often it gets put into the formal lease. But I have seen agents in the past draft the lease agreement for clients, and then that gets left out. And I think this point should be included if you're ever drafting a lease. Even if it's a very simple lease, you should put it into the lease agreement. So when we think about default, right, it seems very straightforward. Again, if you're not paying rent, if you're not doing whatever you're supposed to do. But if you look at the actual lease agreement, the definition of event of default is usually a very long list, right? So what constitutes, what is in the mind of the landlord seen as default or breach of the lease agreement, it's really a long list of items. So it could be non-payment of rent or an obligation under the rent or the lease agreement. Things like abandoning the store, abandoning a business not open. I see that a lot where the landlord has a clause that says if the client failed to open in 5 or 7 days consecutively within a half-month period or a month period, it's considered a breach of the lease agreement. Okay, so also things like if there's a bankruptcy, if the landlord found out the tenant declare bankruptcy, or things like change of control, right? Like things like that, they're all considered default. And the implication of when the landlord can note you in default is, number one, the landlord can re-enter the property. So the landlord can go basically say, switch out the locks, right? Lock you out. That's once there is a default, event of default, the landlord has the right under the Commercial Leasing Act to do that, to re-enter the property. And once that happens, in order to cure that default, depending on the landlord, usually the landlord look for that month of rent and the next succeeding 3 months of rent as cure. So basically, say your client an extreme example, right? Let's say the client went back on vacation or went to vacation for a month, and they come back and they're like, "Oh, why is my shop locked?" Right? And then they contact the landlord, and the landlord said, "Well, you breached this clause under the lease. I switched out the lock, so now you have to pay all the rent and 3 more months of rent in order to bring it up to good standing, and you have to pay all the fees that I incurred as the landlord during this time," right? And if sometimes the tenant will be like, "What? Like, I didn't know about this." And again, like, we know commercial rent could be $10,000, right, or more a month, and they're like, "We don't have like 30,000-40,000 just sitting around to give you." And the landlord could be like, "Okay, too bad. Then you're breach. You're breach, and you have defaulted under the lease." So it's very serious. I mean, most of the landlord, again, we have dealt with, most of them are pretty nice. And, if you're going away for a vacation, they probably won't do that. But they can, right? Again, under the terms of the lease. So it's important to have the client understand. And if you're drafting a lease agreement for the tenant or for the landlord, you want to put in things like what's considered default. If you don't put it in, right, then if you don't put in, for example, that continuous operation of the business, then it doesn't matter, right? Like the tenant could not do anything, and they could still, as long as they're paying rent, and the landlord can't do anything about it. But from the landlord's perspective, you don't want just a unit there vacant, right? Although you're taking rent, but from the business perspective, you want, there's traffic, you want people to come in. You don't want constantly this, half-open business sitting there, right? So that's really important to consider what's considered default, and have the client understand what's the ramification of when they're in breach. And the other is distress. So distress is a self-help remedy. When we say self-help remedy, that means you don't have to go to court. You don't have to go, to some kind of tribunal or organization. The landlord could just do it themselves, which basically means if the landlord is in default, the landlord could just walk into the unit and take whatever it's belonging to the business and sell it, and use that to pay rent or pay any of their cost. Okay, so it's a really powerful remedy that the landlord has, but it's very technical. So if a landlord is thinking of doing that, definitely talk to a lawyer first, because you have to still give notice that there's a certain time you cannot go in the middle of the night, for example. There is like very specific time period you can do it, but the result is the landlord they have the right to self-help by selling whatever you have in the business. And one of my first commercial lease actually was at Midland and Shepherd. That we know there's like big plazas there, and we had a client where the business wasn't doing so well. They closed down the shop, but they left some of their own. They claimed they left some of their personal stuff in it, like tools, quite expensive, like drills, saws, and things like that. And the landlord took it and sold it. and the tenant claimed that these items are their personal items and they don't belong to the shop. And it becomes this huge argument of like if the landlord should have taken it. So I always advise client, like if you have any valuables, like especially if the business is not doing so well, don't leave it in the property. It's really hard for the landlord to distinguish which belongs to the company or belong to you personally. Just take it with you. With that being said, I always have clients who ask me saying, "Oh, well, I don't think I can pay rent in the next couple of months. Can I move everything?" And I'll just be like, "Can I disappear?" Right? So the answer is actually no. So the landlord can trace back anything that they see in the unit. So if any inventories, if they see, you sold it to somebody else, any chattels and any equipment, like big, especially for like for like cabinetry, like any kind of industry, if they see you move it, first of all, you're not supposed to move anything that's in the unit once you move in. But if they see you move it and then they can trace it back, and you're basically pretty. you wouldn't be good on both sides, right? You look bad for the person you sold it to, and the landlord can take it back from whoever you sold it to. So there is this legal protection for the landlord. So we don't encourage to take everything and run. Always encourage, if really it comes to the point where you can't pay rent, try to negotiate with the landlord. Sometimes the landlord would give you a grace period, like half a year or something at a reduced rent. Maybe try to sell the unit, or try to sell the business, come to a mutual release, that kind of stuff. Because under again, like legally speaking, if you committed to 5 years of rent, the landlord is entitled to the full 5 years of rent. The landlord is entitled to the full duration of the term. So it doesn't matter. So I have clients saying, well, I only been here for 1 year. Do I have to pay the next 4? Unfortunately, the answer is yes. The landlord would have the duty to mitigate, which means they have to, if this tenant leaves, the landlord has the duty to list it again really quickly, find an agent, try to rent it out. But if they can't rent it out for like 5 months, 6 months, 8 months, the previous tenant will be responsible, right? So that's the thing with commercial lease is, so most of the terms are based in contract, like based in whatever we put down on paper. There are rules or laws that's that gives like a structure to the area of commercial leasing, but at the end of the day, what we negotiate is what basically the client will have to perform, or what the landlord can collect. So it's really important to do a good job. Okay, so that's all I have for today. If you have any questions or anything you want to share, thank you.